Hello and welcome to the first in a series of family law videos on behalf of DMH Stallard. Stallard. Today we are going to be discussing the introduction of the no-fault divorce. My name is Samantha Jago and I'm a family law solicitor with DMH Stallard. Today I'm going to be discussing no-fault divorce with my colleague Natasha, and I'm now going to hand over to Natasha so that she can introduce herself.
Hello everyone, thank you ever so much for joining us today. We hope you find it a very useful session. My name is Natasha Salabas and I'm a partner in the London office at DMH Stallard. Over to you, Samantha.
So today's video is to focus on some of the key questions that we have been asked by clients and colleagues regarding the introduction of the no-fault divorce, which has received a lot of press coverage. Now, the key question that I'm asked is exactly what is a no-fault divorce? What does it mean? Can you give us an overview, Natasha?
So up till when we come into the new law on 6th of April 2022, we've always had to have one, an irretrievable breakdown of the marriage, and two, one of 5 facts to rely on, which basically blame and shame, let's say, your spouse when you get a divorce. So the new law will remove that blaming game, and it will allow someone to get divorced without having to do so based on the sole reason of irretrievable breakdown by way of a statement. And that can be done solely, or it can be done jointly together if you both agree to do it.
Okay, so let's say that I wanted to initiate divorce proceedings. My husband will be horrified if he watches this and thinks that's what I'm suggesting. But let's say I want to initiate divorce proceedings. It's all very amicable, but I say, okay, I want a no-fault divorce, but then for whatever reason, he won't agree. Can I still get on and initiate a divorce petition on that basis?
Yes, you can. So unlike the old rules, you can basically advance your petition without his agreement. And there is no way for him to defend the fact of irretrievable breakdown. So there are very limited exceptions to that, but they're not based on the defence, so to speak, that it's not irretrievably broken down. And they're based on if, let's say, you didn't have jurisdiction to apply in the first place, or there's a query over whether you had had a proper marriage in the first place, or whether there's some sort of element of fraud. So
okay,
the sorts of reasons now, and that's
just for the benefit of the viewer, the reference to jurisdiction means the power of the courts in England and Wales to actually progress a divorce in this particular country or Wales.
Exactly.
Okay, what about if I actually want to blame my former husband for the cause of the breakdown of the marriage? Let's say they've had an affair. Can I still rely on adultery, or do I have to rely on no-fault divorce?
So with the current legislation, you would be able to use adultery. But as I said before, there is no element of picking one of 5 facts. There is literally just an irretrievable breakdown as the sole option. So you could, within your statement, refer to that very incident, but you don't have to, and there is no defence to it, as I said before. So it doesn't actually matter. You don't need to have a very long spiel on all of the bad things that your spouse has done, but simply say the marriage is irretrievably broken down.
Okay, and you say that we have to have a statement within the divorce petition. What does that mean? Does that mean I have to give a witness statement, which is pages long, or just a very short line saying we're no longer in love, or what exactly does that entail?
So what it entails is that within the form itself, there will be a section that will have detail for you to insert within that section on the irretrievable breakdown. You don't need to make it particularly long. You should probably refer to some detail rather than one line saying there is an irretrievable breakdown, we now want to divorce. But the guidance, seems to be so far that all you really need to do is set that out in a short form.
Okay, and what do you think the advantages are of a no-fault divorce, or do you think actually it's a negative thing that to be introduced?
I think it's actually something we've been waiting for a very long time. I'm sure you'll agree, Samantha. It's something that the UK is far behind on in terms of a lot of the states in America, which had no fault divorce for many years. It's the first change that we've had that's revolutionary in this way since 1973. So it's been, I think we've been calling for it for a long time, and it will remove hopefully a lot of acrimony from spouses when they get divorced.
I think that it will help to set the right tone to the proceedings from the outset of the case and try to get people to work in a conciliatory and constructive manner with one another. But do you think that this change will filter through to how finances and children matters are resolved upon separation, which sometimes can be very emotive and acrimonious?
Well, like the old rules, the actual divorce itself doesn't affect the way the finances or children are resolved by the court. But I think that it removes the inflammatory nature of placing blame on the other spouse, which you otherwise had to rely upon using the old rules when you got divorced. So if that was the first thing the spouse would have seen, which it would have been because you have to petition in order to get a financial remedy on divorce in this country, then it sets a sour tone from the outset. And I think with the new rules in force, there will be less of that and perhaps a more clean slate to start from.
Let's say though that I've got children and I have got concerns about the way that my former spouse has behaved, and I petition because I want to progress matters as smoothly as possible on the basis of no fault. But then in children matters, let's say I do need to raise elements of behaviour with the court so that they can consider it. Will the fact that I have petitioned the basis of no fault affect my ability to do that in, let's say, children or financial matters?
No, it won't affect that ability. It's a freestanding matter. So the divorce court will not deal with children or financial matters as by way of an automatic right. You will have to still deal with that separately, and allegations of bad conduct can be raised within the financial remedies or children proceedings.
Okay, well, thank you, Natasha. That's been really helpful to discuss that with you, and does touch upon a number of the questions I said that our clients and colleagues have been putting to us.